So Liz, I'm curious, what if we were to say that all you can do wasn't a statement on legal or technical ability, but rather was a political statement? Do you think that this is all we can do from a political perspective?
Well, I think that's a very interesting question. And as Michael was talking, I wrote down that some of this question about whether or not the investment chapter is state of the art is a matter of perspective.
USMCA may have also missed the mark a little bit in the sense that there's a lot of things that are happening elsewhere that it has not included. There is no contemplation of the permanent court, no contemplation of an appellate mechanism. So these things seemingly have missed the mark.
But I think in some respects, Canada-European trade agreement is really especially important, given that that's an agreement that in many ways steps farther back from the ISDS model. The protections in some respects are more robust, but in the iteration that is now subject to ratification, the Canadian side essentially assented to the investment court structure that the Europeans have advocated, even if on a kind of more one-off basis, and an appellate component to that structure.
You can have some real objections to the outcome of the USMCA investment chapter, but there were real achievements in the drafting, I think, that I don't want to be lost in this discussion.
For one thing, we now have the WTO, and state-to-state dispute settlement at WTO has become commonplace, and countries routinely bring state-to-state cases at the WTO without wringing their hands over whether that will disrupt broader diplomatic relations. So if it's become commonplace in the trade context in the WTO, why not in the investment context?
But I do think it certainly, to some degree, sets an interesting precedent for the potential for some of those relationships to make distinctions between investors and to carve out and sort of restrain the ISDS mechanism.
I do think that this exclusion of investments owned by non-market economies raises a serious issue under the General Agreement on Trade and Services.
Kate's paper is really excellent, I think, in pointing out the asymmetries in this agreement, and it's another reason why you should read it. And I think this idea that the winners under this agreement are the holders of covered government contracts, primarily in the energy sector. Whether or not they have really won, I think really remains to be seen.